Good afternoon. As Dan stated earlier and the recording just indicated, we are being recorded today. And let me welcome you to the 5th webinar series in our annual series today, our 5th presentation in 2018. We're going to talk about record keeping. Record keeping has been a hot topic for the last couple of years. It's taken a couple turns and made couple detours and trying to figure out what the regulations are for employers, and hopefully we'll add a little bit more clarity to that. I'm going to start off by introducing myself. I'm filling in for Eric, so his voice has not gotten much higher and changed his name. I'm actually another partner in the OSHA practice group and have been with Con Maciel Carey since its start back in, I think, 2014, but been practicing with Eric since 2011. My practice primarily focuses on OSHA issues, anything from enforcement to compliance assistance to rulemakings. I got my start with OSHA as an employee of the Occupational Safety and Health Administration in the national office before moving over to the solicitor's office, where I also focused on safety and health issues. I like to say that I'm probably one of the few attorneys who has focused exclusively on OSHA issues for their entire legal career. But OSHA has been the subject area that I've worked on since I've got out of law school. Handle all aspects of litigation and investigations. And I'm going to turn it over to Dan to introduce himself.
Great. Thanks, Amanda. My name is Dan Deacon, and I am an associate here at Con Maciel Carey in both the OSHA Workplace Safety Practice Group and the Labor and Employment Group. I've been with the firm since 2015, and I represent employers during inspections and investigations conducted by federal and state OSHA. I advise and counsel employers in responding to notices of employee safety complaints and OSHA citations. And I also represent and advise employers in all aspects of the employer-employee relationship, including wage and hour disputes, claims of discrimination. And I also assist employers in revising their handbooks and generating workplace policies and procedures. So I'm going to kick it off with a high-level overview of our agenda today. We have a full slate of materials to go over with all of you. We're going to try and keep it within the hour that we have planned here for today. But as you see on the screen, we have 4 main topics that we're going to go over. First, we're going to begin with the injury data e-submission requirements, and then we're going to talk a little bit about how you submit your 300A data on OSHA's injury tracking application, the website portal where you submit your data. And then Amanda's going to talk about the anti-retaliation elements of the rule, and we'll conclude with the future of OSHA's E-Recordkeeping Rule and what we can expect in the next few months with the anticipated Notice of Proposed Rulemaking. So as I mentioned, we're here today to talk about the rule from beginning to end. And we're going to talk about all the elements, the e-record-keeping portion and the anti-retaliation elements. And as you all are probably aware, this is a rule that was promulgated back in May 2016, but it's had some considerable changes and news highlights along the way. And we're going to talk about some of those today as well. So let's start with the e-record-keeping portion and the data submission requirements. So as I just mentioned, in May 2016, OSHA published the final rule, and the data submission requirement went into effect immediately. And there's 2 major provisions to the rule that you should all be aware of by this time. And the first one is establishments with 250 or more employees must annually submit to OSHA 300 logs, 301 incident reports, and 300A annual summaries. And 2, the second major provision was establishments with 20 or more workers in high hazard industries must annually submit 300A data. So we're going to dive into what the definition of an establishment is, how you calculate that applicable employee count, and how to determine whether an establishment falls into a high hazard industry in a couple of slides here. But these are the 2 major provisions that are your guideposts to determining whether you are covered by this rule. So initially under the rule, all establishments, regardless of whether they fell into the high hazard category, were only required to submit 300A data by the December 31st, 2017 deadline. That was the initial submission deadline. Remember that it was originally supposed to be July 1st, 2017, but then it was extended on several occasions. I think it was about 3 times from early December to mid-December, and then finally the end of the year, December 31st, 2017. And that was for employers to submit their 2016 300A data. By the July 1st, 2018 deadline that's coming up, however, establishments with 250 or more employees were supposed to submit their 300A data and their 300 logs and 301 forms. Establishments with 25 or more employees that fell into the high hazard industry classification were still only required to submit 300A data only. However, President Trump announced in his fall 2017 regulatory agenda an intent to revise OSHA's E-Recordkeeping Rule, including removing that requirement for establishments with 250 or more employees to submit their 300 logs and 301 forms. So shortly after that agenda was published, without any notice and comment rulemaking, OSHA updated its instructions on its website and the ITA portal for establishments with 250 or more employees to submit only 300A data by the July 1st, 2018 deadline. So going forward, for this upcoming July 2018 deadline, any covered establishment, regardless of the size and the employee count, are only required to submit 300A data. So I mentioned earlier that we are going to discuss the applicable employee count for purposes of determining whether an establishment is covered under the rule. To calculate the employee count, you use the total number of employees at peak employment during the year at that establishment, and that includes temps, seasonal workers, and part-time employees. So if you have more than 25 or more employees at any given time of the year and you're in a high hazard industry, you're covered by the rule. Likewise, if you have 250 or more employees at any given time of the year, including those temps, seasonal workers, and part-time employees, then you're covered by the rule, even if it's only for a short period of time. To determine what an establishment is, it's defined as a single physical location where business is conducted or where services or industrial operations are performed. So when determining this employee account, the employee count and the establishment inquiry, remember that it requires a location-by-location assessment. And I see we're getting a couple questions coming in here, and I think I'm going to answer all of them on these next couple slides. So here's the steps you're going to take. The employee count can be done by the corporate entity, and it needs to be done for each particular location. And you need to, step 2, determine whether that number meets one of the reporting thresholds, 25 or more employees, and you must fall within a high hazard industry, or 250 or more employees at that establishment. In determining the NAICS code, to determine if you're in that high hazard industry classification, the guidepost here is the primary business activity done at the establishment based on the share of production costs or capital investment. And this may differ for headquarters and for different locations. There could be different NAICS codes. So not one single NAICS code is likely going to apply for every single establishment. Also, it's worth mentioning that a single location, a single physical location may or can have 2 or more establishments, and that's going to be governed by 29 CFR 1904.46. And that starts with the presumption that normally a single physical location should be treated as one establishment. But the regulation does make an exception where 2 or more separate businesses share one location. So in explaining this exception in the preamble, actually, OSHA conceded that it allows for separate establishments when an employer uses a common facility to house two or more separate businesses. So this can apply in situations where there's side-by-side operations at one physical location, and they're operating as separate businesses because they're engaged in different lines of work. So for example, if you have your headquarters located in the same physical location where you have a manufacturing facility on that same property, those can be separated likely, and they're going to have two separate NAICS codes. So this slide demonstrates the numbers that OSHA anticipated receiving when it promulgated the rule. And as you can see here, the anticipated number was quite high. It was quadrupling the total number of employers required to submit injury data to the Department of Labor. For establishments with 20 or more employees, that jumped from 160 to 440,000 sites. And for establishments with 250 or more employees, that jumped from 38,000 to 129,000 sites. And as we'll discuss later, those numbers were off a little bit, well, actually by a lot of it. But there's a couple reasons for that, and we'll dive into that in a little bit. So the data submission issues here, we're just going to cover a couple of the common questions that we get from employers about the ITA portal and the submission requirements. So generally, the data here is submitted through the injury tracking application, and that's accessible through OSHA's record-keeping webpage. And the second bullet here is one of the big questions that we get is who can handle the actual submission of the data to OSHA? Can it be one person at corporate headquarters, or does it have to be an individual at each separate establishment? Well, it can be handled by either. It can be handled by each individual establishment on their own, or corporate headquarters can handle the data submission for all of the covered establishments under the rule. There's no hard and fast rule about who submits the data as long as it gets submitted. OSHA has had some problems with the injury tracking application in its early stages when it was being rolled out. I'm sure many of you are aware, the Department of Homeland Security informed OSHA that there was a potential security breach last year, and the website was actually taken down for a couple weeks. And this was, of course, after it was professed that the data would be submitted through a secure website, and OSHA was going to scrub employee identifying info. It appears that the kinks have been worked out and there's no longer a problem. And with reference to the scrubbing employee identifying information, since 300 logs and 301 forms are no longer required to be submitted, this isn't going to be a problem. And the ITA portal isn't even set up to accept that data. So those security concerns and the privacy issues that arose last year were likely a contributing factor to making that decision to remove the requirement to submit 300 logs and 301 forms, and it certainly provides employers a bit less of a burden and some reprieve from those strict requirements. I should also mention that the last bullet here, the original intent of the rule was to publish data publicly on a website in a searchable forum, but that is no longer the case, and perhaps some of you have been keeping tabs on the recent case filed in federal court in Washington, D.C. by public citizens. That case concerns FOIA requests. I'm going to discuss that a little bit later, but the Trump administration is not providing the data in response to FOIA requests right now. This was a major concern and a loophole that unions, plaintiffs' attorneys, and the public generally could use to obtain those records that were submitted So keep a close eye on that case and the potential outcome, as it's going to have a pretty big impact on the public access to that data. So this was a quote from former Assistant Secretary Dr. Michaels last year, or in 2016, when the rule was promulgated, and this just goes to show the primary intent of the rule, and it was to nudge employers to prevent working injuries, to show investors, job seekers, customers, and the public they operate safe and well-managed facilities. And what we see here now is a little bit of change of course from that focus on the employers and nudging them to provide this data and be transparent. And the Trump administration has taken a little bit of a change in that direction. And the rules had a lot of twists and turns since it was originally promulgated. As I mentioned, the concern about privacy purportedly motivated that change not to collect 300 logs and 301 data, and the Trump administration has rejected the plan to publish the data on a publicly accessible website. So that brings us to the current lawsuit pending before District Court in Washington, D.C., and that was filed by a public citizen against the Department of Labor. In October, November, and December of last year, public citizens submitted FOIA requests for the injury and illness data that was submitted under the rule by that December deadline. Public citizen intends to use that data to conduct research on workplace safety and health, but OSHA denied those requests, the October and November requests anyway. It stated that it had identified 23,461 records that were responsive, but it claims that they're exempt from FOIA because their release would disclose OSHA's techniques and procedures for law enforcement investigation. So keep track of this case. Again, it could have a pretty big impact on how quick data can be collected by the public in the near future. Based on OSHA's response, it appears that the data will have to be disclosed at some point. OSHA's justification for not disclosing it, the data right now, is because it's being used to select establishments for inspection, but it's unclear how long that's going to take.
And Dan, just to add a little bit to that, usually OSHA had a practice prior to its electronic data record-keeping data requirement. They had sent out surveys to companies, and they would collect much similar information, injury and illness information, and they would keep that private and would not disclose it for the public for about 2 to 3 years. And then it would be disclosed to the public after they used it to do their site-specific targeting. And that usually came out in the form of a FOIA notice posted on OSHA's FOIA page, which is a little bit hard to find on their website, but it usually it was there and it was easily accessible. So just pointing out that it's kind of a continuation of what had been under the previous policy, and it usually took about a 2 or 3 year delay before it was actually released to the public, the data, record-keeping data that was collected for SST targeting.
Thanks. So on to this next slide here. This is just a quick overview of the key reporting deadlines. As you see, the first data submission deadline eventually was December 31st, 2017. Remember, it was originally supposed to be July 1st, 2016, and that was pushed back several times. We have the upcoming deadline, July 1st, 2018. 300A data is the only data that needs to be submitted by all employers, all establishments that are covered under the rule. And then going forward next year, when you go to submit your 2018 data, the deadline will be March 1st, 2019. That may change. Remember, we have an anticipated Notice of Proposed Rulemaking that should be coming out within the next couple months. So that deadline may be changed, but for purposes of the rule itself in the future, which we'll talk about at the end of the presentation, it looks like the data submission requirement is here to stay, and that there will be a requirement to submit at least 300A data in the future. It's unclear whether there's going to be a change to the employee count. So we'll see what changes come here in the future. So over these next few slides, we're going to talk about some practical data submission issues and actually how you work the injury tracking application. So once you set up, once you access the ITA portal itself, you're going to create an account and your login information. And one of the first things that you get is what corporate name should be used under the company name field. Well, you want to use the corporate entity responsible for the day-to-day supervision of employees. And then step 2, you want to decide between manual data entry, batch data transmission, or API plugin. And those are the 3 different options you have. And depending on what size employer you are, if you are submitting data at corporate headquarters on behalf of multiple establishments, you're probably not going to want to use the manual data entry. That might be a little burdensome and time-consuming. There's other quicker ways to do it, that being the batch submission option or the API plugin, where you need to work with OSHA and your internal IT to set up those submission logistics. But for purposes of the first option there, the manual data entry, if you want to use this option, you're going to have to create an establishment. There's going to be a Create an Establishment button, as you see on the drop-down menu there, and you'll add your first establishment to the system. The next step is to add the 300A data to it and then submit it. It's pretty self-explanatory. And you can submit multiple establishments under the company name field and submit that data. Again, it's just doing it manually, one by one. The batch data transmission option, that can be used if you want to insert data for multiple establishments at one time. To enter data for those multiple establishments, you begin by clicking Upload a Batch. Again, you see this in the drop-down menu on the navigation, or the navigation menu there, which is in the ITA portal. And that's going to direct you to a file upload page where you'll find information on how to create those batch files and upload them for submission. So once you click Create an Establishment button on the ITA home screen and you fill out the establishment name field with the name of the business, and again, this is, let's take one step back, this is for the manual data submission portion. The company name field asks for the name of the company that owns the establishment, but this field is not required to be filled out. So what we suggest is not filling that out. The establishment name can be unique to the establishment itself, of course. So if you don't have a particular name for an establishment, or you have the same or similar names for multiple establishments, you can be creative in identifying those, because you'll of course have to submit the address, city, state, and all that information as well. And here we'll talk about editing data in the ITA portal. We sometimes get questions about, oh, I am trying to upload my data and I noticed a mistake, or I need to edit something, or I've already submitted my data but I noticed something was wrong and I want to amend that. So here's the 3 common questions, I guess you could say, that we get about editing your data. First, if you want to edit an establishment, you're going to use, again, that drop-down navigation menu and click View Establishment List. You're going to click the name of that specific establishment that you want to edit and modify those appropriate fields, whatever it's going to be. And then you're going to click Save. If you're doing this through the batch submission process, that's through the CSV file, you're going to have to upload an entire new CSV file. If you want to revise the 300A data prior to submission, again, you use the drop-down menu on the navigation page, click the View Establishment List, and select the specific establishment, and then click Edit 300A Summary. And then you can edit those appropriate fields, save it, and it'll be uploaded. And then, again, I mentioned revising 300A data after you've already submitted it. If you notice there's a mistake or it needs to be amended, you simply upload a new file and hit Submit. So let's talk a little bit about the first year of the record-keeping rule and how the rollout really went. Of course, employers submitted their 2016 300A data by December 31st, 2017, or at least they were supposed to. The deadline, again, as we've discussed multiple times now, it was pushed back. Originally set for July 1st, 2017, and then it was moved to December 1st, December 15th, and then all the way to December 31st, 2017. So OSHA only received 214,000 submittals, and if you remember at the beginning of the webinar, we talked about those projected numbers, and they were over 450,000 or so expected submissions, and they received less than half. So some of the justifications for why they received less than half of what they were expecting was, one, a less than smooth rollout of the injury tracking application. We've covered some of those problems with the security hack or the potential security breach, where they had to take the portal down for a couple weeks to work out the kinks, and there's some fear and confusion about the status of the rule and how the ITA would actually work, and then, of course, the numerous delays and announcements of changes to come. Employers were kind of left in the dark of how to comply with the rule, as well as the ITA portal's instructions aren't very clear. And then finally, not all state plans have adopted the rule. And we're going to talk about that in more detail given the April 30th press release instructing establishments in state plan states that have not adopted the rule to submit their 300A data by this July 2018 submission deadline. So during a webinar presentation earlier this month, the OSHA Office of Statistical Analysis Director, Dave Schmidt, said that OSHA was taking a liberal approach to employers that didn't comply with the rule and didn't submit their data by the December 2017 deadline. But that doesn't really appear to be the case. OSHA issued an enforcement memorandum in late February 2018 to its regional administrators regarding the agency's policy for non-responders. So as part of any on-site inspection right now, OSHA is instructing its compliance officers to inquire whether the establishment has filed their 2016 300A data. If the compliance officer learns that the establishment was required to do so and did not, OSHA will be issuing an other than serious citation for failing to comply with the regulation, and the potential penalty ranges from 0 up to the max. However, OSHA also stated in that enforcement memorandum that it has 6 months from December 15th, 2017, even though the deadline was technically moved to December 31st, 2017. So between December 15th, 2017 and June 15th, 2018, that is the window in which they can issue citations for failure to report. So it looks like, yeah, today is May 15th. If you haven't submitted your 2016 300A data, hang on tight. You have 1 month to go before the statute of limitations runs, about a month. OSHA also indicated that it's going to be conducting a mass mailing outreach to employers who didn't submit their 300A forms and informing of their obligations to do so. And they're currently reviewing those 300A data that was submitted, and they're intending to use that to develop inspection targeting similar to site-specific targeting. And as you see here, this is an example of one of the citations that has been issued and that we've come across in our experience. And the overarching concern here is there's, it's an other than serious citation, and the penalty may be 0. If a compliance officer comes to the work site and finds that you didn't submit your records, but you comply during that inspection, or if you submit your 2016 data shortly thereafter, you're not going to incur a penalty. If you fail to do so, you're still going to receive an other than serious violation, and the penalty could be, $12,934. So the big concern here is there's still a regulatory risk, and there's of course a potential for a repeat, and who knows what the potential penalty could be for that, but it could have some long-term consequences. Now we'll go into the discussion that I'm sure a lot of you are eager to hear about, and that's the state plan states. So currently there's 7 state plan states that have not adopted the E-Recordkeeping Rule. And as you can see on this slide here, those states are California, Maryland, Minnesota, South Carolina, Utah, Washington, and Wyoming. All of the others, the deadline to submit the injury data, the remaining state plan states have adopted the final rule, and employers or establishments in those states need to submit data by the July 2018 deadline on the federal OSHA portal. So let's talk about the topic you've been waiting to hear about, the press release from OSHA on April 30th stating that employers need to submit their 300A data by July 1st, 2018, regardless of whether they're located in a state plan state that hasn't adopted the final rule. And as I mentioned, there's 7 that still have not adopted a final version of the rule. The press release specifically states Section 18C7 of the Occupational Safety and Health Act and relevant OSHA regulations pertaining to state plans require all affected employers to submit injury and illness data through the ITA portal, even if the employer is covered by a state plan that has not completed adoption of their own state rule. OSHA also stated that there's not going to be any retroactive requirement for employers covered by state plans to submit their 2016 data. So this would just be the 2017 300A data being submitted by this July 1st deadline. What has resulted, however, is some conflicting responses from the state plan states. And we'll cover those here. So what are those? First, we have California, who is advising employers to submit 300A data on the ITA portal. Maryland, the website still states that Maryland employers do not have to submit the 300A data. Wyoming, shortly after OSHA's press release was published, issued a statement confirming that the rule does not apply to Wyoming employers and they don't have to submit data. Utah instructed employers that they may submit 300A data, but they're not required. Washington issued a statement informing employers that they're still not required to electronically submit data. And in South Carolina, there's not been a clear statement, but they expect to have the rule finalized in the next few weeks here. Likewise in Minnesota. So those responses vary, quite considerably, but none of them affirmatively state that an establishment is required to submit their data on the ITA portal. So the big question here is, if you're in a state plan state, are you required to submit data? In other words, can OSHA compel you to submit your 2017 300A data by this July 2018 deadline? And the answer is no, you're not required. And there's no regulatory risk for not submitting that data. Section 18C7 of the OSHA Act, which cited by OSHA in its press release, does not give Fed OSHA any authority over state plan employers. It only gives them authority over the state plans themselves. It sets the minimum requirements for state plans to be eligible for approval by federal OSHA of the state plan. So the Secretary must approve a state plan if the plan, in its judgment, requires employers in the state to make reports to the Secretary in the same manner and to the same extent as if the plan were not in effect. The remedy here for delinquent state plans, if you will, is to rescind their approved state plan status, not directing employers in those states to submit their 300A data. There's no regulatory requirement to do so, nor is there any regulation for which they can be cited for failure to submit the data. And there appears to be a consensus among both federal OSHA and the state plan states that they wouldn't have any authority to enforce such a directive or issue a citation to that effect. So for purposes of the July 1st, 2018 deadline coming up, establishments and state plans that have not adopted the rule don't have to submit data in the ITA portal. And that's probably why you see the very careful language used by the state plan states indicating that you can if you want, but there's nothing indicating that you're required to do so. And with that, I'm going to turn it over to Amanda, and she's going to cover some of the anti-retaliation elements of the rule, and we'll take a look at some of the questions here at the end.
Okay. Hi. Talking about the anti-retaliation elements in the record-keeping rule, the anti-retaliation elements were a little bit surprising for a couple of reasons. First of all, the record was termed and called record-keeping, so we weren't really anticipating the degree of anti-retaliation elements that were included in it. And also, they weren't fully explored as part of the rulemaking. And so they needed to, it was a bit of a surprise to see them in the final rule when they had not been thoroughly discussed as part of the rulemaking. Another reason it was surprising is because OSHA's statutory statute gives OSHA the authority to investigate retaliatory claims. It's a statutory requirement that Congress granted OSHA when they delegated the responsibility for occupational safety and health promulgation of standards and enforcement back in the early 70s, and it's been used. It's Section 11C. OSHA has its own department that investigates retaliatory claims and can pursue remedies under that provision. So we were a little surprised to see that the level of detail that was included in this rule. At a high level, there was basically three provisions that dealt with anti-retaliatory aspects. The first two inform employees of a right to report workplace injuries and inform employees of a right to report work-related injuries free from discrimination or retaliation. While they could be confusing, OSHA came out with pretty explicit interpretation letters saying that as long as you downloaded a new sign that is available on OSHA's website and post that in your workplace, you have met those two requirements. You're already required to have a sign in workplaces, and the language changed a little bit on the updated sign that came out in 2016. So as long as you're posting that sign in your workplace, you've got the first two elements pretty much covered. The third element, anti-retaliatory provision, was a little bit more all-encompassing and a little bit more confusing. Update internal injury reporting practices to remove unreasonable elements. be considered to be a little bit more confusing, and we'll spend the next couple slides looking at that in more detail. These elements, especially the last anti-retaliatory provision, came about largely because OSHA at the time, the previous administration, under the Obama administration, David Michaels, had a suspicion that there was universal underreporting and was largely due to retaliatory acts. He tried to demonstrate this through a national emphasis program when he first came into the office in 2009, 2010, and didn't really find the evidence that he needed there, but still had the opinion that there was widespread underreporting due to retaliation. And so this was one of the ways that he attempted to address what he considered to be the problem. Unwrapping the unreasonable and looking more closely at what is considered to be unreasonable, let's look at OSHA had some terms with regards to internal injury reporting policies. It said that it may cite employers for implementing policies with perceived retaliatory effects for reporting injuries. The types of reporting requirements that they were specifically directing their focus on were late injury reporting. Policy, some employees I've seen that you must report a injury within 3 days of its occurrence. Those are exactly the type of reporting requirements that OSHA was focusing on. They think that that's discriminatory if it is a MSD or ergonomics-related issue, that sometimes it takes a little while for that injury to surface and become recognized by the employee. So they would likely potentially be out of the reporting guidelines. Also, too, so late reporting. And also vague work rules, such as work safely or maintain situational awareness, finding that disciplining employees based on those vague rules and terminations would be considered retaliatory. OSHA's come out with some advice on this through guidance, and as it is today is that the employee has to be reasonable, and OSHA considers as soon as practicable after realizing they have a reportable injury. So that would handle those MSDSs and other illnesses that might have a longer latency period. Haven't seen too many issues with regards to this. Employers were reviewing their policies when this rule did go into effect, and I think the vast majority, if they did have tight constraints, 3 or 4 days, there were some language changes associated with the policy, but haven't seen or don't recall any enforcement actions related to this, and was pretty well, from what I understand, has not created a ton of problems from the employer community. And another important factor that OSHA does considering whether these rules are appropriate is discipline. If employees do not report the reportable injury within the requisite time, that employees are disciplined consistently. It's not preference for one employer, one injury, but there's a consistent practice there. Another issue that has gotten more attention than the internal provisions with regards to injury and illness reporting in the work site is drug testing. This particular issue caused the employer community, created a lot of questions, and we fielded a lot of questions with regards to this. But OSHA was saying that any drug testing after an employee reports a workplace injury or illness could be viewed as retaliatory. Basically, an employee would not report the injury in fear of taking a drug test and viewing it as a form of discipline. OSHA came out and said that they prohibited blanket post-injury drug testing policies. They did provide some limited exceptions with regards to drug testing that was not related to an injury. They did say that was appropriate. And they also noted that when drug testing is required for state or federal law or workers' compensation, that it would be acceptable. Another provision when it originally came out was post-accident, if reasonable basis to believe that drugs and alcohol contributed to the incident would be a legitimate basis to drug test an employee after an illness or injury occurred in the workplace. That within itself in the regulatory text was very confusing, and based on the drug tests that were available in the community or available to employers was a little muddled and hard to understand. But subsequently, OSHA has come out with some practical guidance to interpret what this really means. They've provided a four-prong evaluation, 4 factors to consider to determine whether or not it would be reasonable. Looking at the type of incident, if an employee was stung by a bee outside mowing grass, that likely would not be an injury that would be serve as a reasonable basis for drug testing, as opposed to having a forklift driver run over an employee or an employee's foot. That would seem to be more within the reasonable category for drug testing. So looking at the type of the injury, the circumstances to determine whether it would be reasonable to do drug testing has to have a reasonable basis. Whether other employees involved in the incident were also tested. So basically going back to the forklift example, if you only tested the forklift driver and not the injured employee, that would be suspect to OSHA whether or not you're applying the drug testing policy consistently. Evaluating the level of hazard in the workforce and looking at whether or not the drug test is capable of measuring impairment at the time the injury occurred. So that could possibly, most likely related to alcohol tests, whether the employee, if the drug testing occurred pretty close to after when the incident took place. OSHA did provide an example. They talked about a crate incident where there were several different employees working nearby in a close area. You have the crane operator, the spotter, and some other people that might be maneuvering the load. When the cause of the incident is unknown, say some employee was knocked off of a girding, if you only tested the crane operator and not the other individuals associated with the work, such as the spotter or just generally all of them, that would be suspect to OSHA and could potentially be viewed as retaliatory. So they provided an example as reasonable to attest all employees whose conduct could have contributed to the incident, reasonable possibilities that results of drug testing could have insight about root causes of incident, and unreasonable to test only injured employees. So that was the guidance that OSHA provided and seemed to answer a lot of questions that originally existed at the time that these anti-retaliatory provisions came out from OSHA. Another big component on the unreasonable aspect was safety incentive and compensation programs. There had been a focus in this area based on VPP members, but it not applied to the broader workplace community or the employer community regulated by federal OSHA. And this was basically an expansion of what we had seen in earlier VPP guidance to employers. They were going after the pizza parties that employers were offering to the workforce if they went a number of days without injuries or recordables. OSHA was saying that that was not compliant and they would issue a citation for programs like that. They were giving some examples of what would be acceptable and what wouldn't be acceptable. The pizza party based on no employee injuries for a period of time would be unacceptable. A raffle for a car where only employees who did not report an illness or an injury for a duration of time would not be permissible. On the other hand, a raffle in a month that all employees comply with legitimate safety rules. They encouraging and not penalizing anybody for reporting an injury or an illness, those sorts of programs would be acceptable. Any sort of reward or denial of benefit based on an injury rate. Seen some employers where They have a incentive program that if the worksite exceeds the DART rate or the industry DART rate as published by BLS, they might not have access to a bonus pool. OSHA was saying that those were non-compliant. On the other hand, bonuses where employees were observed working safely. If there was a spot check and employees were working and following all safety rules, a bonus in those situations would be appropriate. As a general rule, frontline supervisors and annual bonuses tied to injury rates was viewed negatively by OSHA, thinking that that frontline supervisor could have some impact on what was reported by the injured employee or employer, and that there could be potential retaliation for reporting it. They did suggest that senior managers and executives that are in the front office removed from the day-to-day reporting or issues with regards to illness and injury reporting and record keeping could have a bonus tied to that. They viewed that as less likely to contribute to a retaliatory situation. The guidance that came out, we're seeing kind of a move that's loosening up on these particular provisions that were in the original record-keeping rule. When it was issued in late 2016, and the guidance that was put out around that time was more rigorous, had a higher standard, and as we've seen a new administration come in early 2017 and get their feet on the ground, we're seeing a little bit of a pullback with regards to guidance, and one of the ways that we've seen that is in the BPP memo, as where some of these more stringent provisions originally appeared before the record-keeping rule. They seem to be backing up and taking a more, I don't want to say, well, more realistic, more willing to consider more factors. They're not making it a blanket non-compliant situation. They're evaluating each program to determine whether or not there are any sort of retaliatory, whether there's a retaliatory impact, or if they have built-in precautions to ensure the program does not discourage reporting. And this was a memo that was issued by the Trump administration in August of 2017. So we haven't completely seen a rollback with regards to the guidance issued by the previous administration, which is some of the guidance that was here with regards to November 2016. But we know there's some enforcement going out on with regards to the provisions. They still are in effect. But I wouldn't say that it would be unusual or would not be significantly surprised if we see guidance develop either through a publication on the website or through the ongoing rulemaking that is currently taking place. The status of these anti-retaliation elements of the rule. They currently are in effect. They came in late 2016 or shortly thereafter and are being enforced. The anti-retaliation elements, even though they do theoretically grant OSHA to investigate a retaliatory situation without a complainant, OSHA has to this point limited those inspections to where there has been an employee aggrieved or negatively impacted. I think one of the main differences between the 11C provision, the statutory provision that's been in existence since OSHA has, is the timeline. The OSHA has broader jurisdiction to investigate anti-retaliation elements beyond the time frame that an employee would have to make a complaint to OSHA. It broadens the window that they can investigate those whistleblower claims. The legal challenges Dan mentioned, there's 2 legal challenges going on. The anti-retaliatory provisions are also wrapped up in the record-keeping challenges. They've been put on an administrative stay at this point, and largely due to the pending rulemaking that the Trump administration is suggesting going to deal with a lot of the issues that are in litigation in those cases. Just once again, here's the case cases that have been filed and are currently on stay waiting for the OSHA rulemaking to be published, which is actually somewhat surprising that it's taken this long, but I would optimistically say that it's likely to be published in 2018, but rulemakings take much longer than anyone ever expects, so I'm cautiously optimistic that it will be published in 2018 and we can have some real clarity with regards to what's going on with record keeping in this area. The key provisions that were challenged with regards to anti-retaliation, these safety incentive programs, asking whether OSHA really had evidence to support that there was underreporting and whether or not they actually had the authority to go after anti-retaliation separate and apart from the 11C actions, which is the statutory provision. They were also looking at the data submission challenges. Likely, I think if this case would proceed, I think there's probably a stronger possibility that the employer community would have a better chance of invalidating the anti-retaliation versus the data submission, but it's all speculation at this point. And I'm going to turn it back over to Dan to talk about the future, continue talking about the future of OSHA's E-Recordkeeping Rule. Thank you.
Thanks, Amanda. We have a few more slides here to get through, and I know we're coming close to the hour time limit that we had set here, so I'm going to get through these as quick as possible. Beginning first with the future of the data submission requirement and the anti-retaliation provisions. So OSHA will soon apparently issue the Notice of Proposed Rulemaking to reconsider, revise, or remove provisions of the prior rule. And if you have taken a look at the most recent spring, the 2018 spring Unified Agenda that was released, the expected date on there is July. But again, as Amanda has pointed out, rulemaking does take a while, and you know, it's fairly speculative at this point when that will be released. There is the potential for a possible extension of the July 2018 submission deadline, especially if the Notice of Proposed Rulemaking does arrive prior to that deadline. But given the recent April 30th press release, we don't think that's likely. So July 1st, 2018 will probably be the submission deadline for your 2017 300A data. But what can we expect in that Notice of Proposed Rulemaking? What types of changes? Well, first, the injury data that you need to submit is going to be limited to only 300A annual summaries for all employers in all years. And they've already indicated that just by updating their website, the actions that they've taken for this year's data submission, and it's been announced in that 2018 regulatory agenda and prior ones. Another likely change is increasing a threshold trigger for high hazard industries or the size threshold for covered small employers. Again, that the threshold right now is 20 or more employees at an establishment. So that range between 20 and 249 that fall into a high hazard industry. We may see that 20 number raised. And then finally here, there may be changes to the anti-retaliation provisions and perhaps elimination of them altogether. The August 2017 VPP memo, which was related to safety incentive programs, certainly softened OSHA's view on those issues, but it didn't fully eliminate the anti-retaliation guidance. So that is one of the big question marks out there, is what's going to happen with the anti-retaliation provision. So going forward, what should employers do now? Well, first you're going to want to provide some refresher training on injury and illness record keeping requirements and make sure that the persons that are submitting the 300A data this year are aware of what's going on, how to use the injury tracking application, and the potential changes that are likely on the way. You want to audit your injury and illness record-keeping forms, make sure those are up to date. And finally, you want to evaluate and update your injury reporting policies to ensure that they're not burdensome and discouraging injury and illness reporting. You want to look at your drug test policy to make sure it doesn't discourage reporting or comply with workers' compensation or any of the other legal requirements. And finally, take a look at your safety incentive programs and your management compensation to ensure that they don't chill reporting of injuries. I mentioned that the August 2017 VPP memo softened OSHA's view on safety incentive programs and rate-based programs, but there are some precautions that you still need to take to make sure that they're compliant. And you should certainly consider increasing random drug testing. I saw earlier we had a question about selecting employees for drug testing. You can certainly use random drug testing. That's not prohibited by the rule, and if anything, it should be further encouraged at this point. If drug testing in your workplace used to be routine and integral to the workplace, and now you have concerns about those post-incident drug testing and the potential remedies that can arise out of that, certainly increase the use of random drug testing. That's one way to keep employees on their toes and make sure that they're complying with your workplace policies. 2, here, post the latest version of the OSHA rights poster or inform employees of their right to report injuries without retaliation and how to report. Those are in the record-keeping regulations itself. And finally, as our colleague Eric likes to say, if OSHA shows up, hide the empty pizza boxes. And with that, we're going to end the presentation. It looks like we just went over an hour. If any of you guys have any questions, feel free to type them in the chat box, or feel free to reach out to Amanda or myself. Our contact information is going to be at the end of the presentation, and it's going to be on the slides that you will all be receiving, along with a audio recording of the webinar. That'll be sent out to you within the next 24 hours. And keep an eye out for our upcoming webinars that we have in the near future. The next one being June 5th on joint and multi-employers, contractors, and temps. And to stay up to date on recent OSHA news, check out our blog, OSHADefenseReport.com. And again, feel free to reach out to me or Amanda with any questions that you have regarding this presentation or any OSHA issues that you may have.